PVL3702 Law of Contract, Chapter 1, Number 1.7 The Basis of Contract. In this section, we address the fundamental question, what must be proved in order to establish that a contract exists? 1.7.1 Introduction. We have said that in modern law, all contracts are consensual, in that they are based on agreement. But what do we mean by agreement? Does it require a genuine meeting of minds on all aspects of the contract, or will an objective appearance of agreement suffice? In other words, does our law adopt a subjective or an objective approach to the formation of a contract? That is one of the most fundamental questions in any system of contract, as the answer to it influences all that follows. 1.7.2 Actual subjective agreement, consensus. Genuine agreement presupposes an actual meeting of the minds of the parties, concursus animorum. Subjective consensus of this nature exists when all the parties involved, first, seriously intend to contract, secondly, are of one mind ad idem as to the material aspects of the contract, namely the terms of the presupposed agreement and the identity of the parties to it, and thirdly, are conscious of the fact that their minds have met. As a learned commentator has pointed out, it is not enough that you wish to sell me your book for 1,000 rand, and that I would be willing to buy it at a price. Our minds are on parallel tracks, but a contract emerges only when the tracks intersect. Consensus is achieved through a process of communication involving declarations of wills by the parties. The declarations may be expressed in words, by conduct, or even by silence in some cases. The process is traditionally analyzed in terms of offer and acceptance. A makes B an offer, which upon acceptance by B produces consensus. At the risk of stating the obvious, the communication of an intention by A to B has three aspects. First, the true intention of A's mind, that is, A's inner will, the message intended to be sent. Secondly, the expressed intention, that is, A's declaration of will, the message sent. And thirdly, the perceived intention, that is, B's belief or understanding of what A intends, the message received. Ideally, A will express his intention clearly and B will understand perfectly what A intended to communicate. The true intention will coincide with both the expressed intention and the perceived intention, and perfect consensus will have been achieved. 1.7.3 Apparent or objective agreement. As all too often happens, however, there may be some divergence between the true intention and the expressed or perceived intention, with the result that the message sent or intended to be sent is not the same as the message actually received. This divergence may be due to a hidden mental reservation on A's part. He said one thing but secretly intended something rather different, or due to some misunderstanding or mistake. A may have expressed his intention badly, or B may not have paid sufficient attention to what A said or wrote. In such cases, there is dissensus rather than consensus, and the question is whether any contract can have come into existence between the parties. Since all contracts are said to have been based on agreement, one might think the answer is obviously no. However, what if, despite the absence of actual agreement, there is an objective appearance of agreement created by the conduct of one party and on which the other has reasonably relied? For example, B appends his signature to a document that clearly and unambiguously states the terms of A's offer. Should the law in such circumstances not protect A's reasonable belief that the agreement has been reached, at the very least if B was at fault in creating the impression that she assented to A's terms, and if A would be prejudiced if the existence of the contract could be denied? Consider the following scenario. Having applied for a job in another city, you are invited to an interview. You attend the interview and it seems to go well for you. You subsequently receive a letter from your prospective new employer informing you that your application has been successful and that the job is yours. In reliance on that letter, you resign from your present job, sell your house, and make arrangements for the movement of your furniture and effects to your intended new home. But then you receive a further letter from the prospective employer informing you, with appropriate apologies and embarrassment, that the letter of appointment was addressed to you by mistake, and that it should have gone to another person interviewed by the selection committee. Could you not insist that a contract exists, despite the mistake? Whether or not a legal system will uphold a contract in such circumstances depends upon whether its approach to contract is wholly subjective, that is, focused on an actual meeting of minds, or, to some extent at least, objective, that is, focused on the external appearance of agreement. The choice of approach will depend upon why the system in question regards a person as bound by a contract. This raises philosophical issues on which a number of theories have been advanced, particularly in continental legal literature. 1.7.4 Theories of Contract. According to the will theory, the basis of contract is to be found in the individual will. The parties are bound by their contract because they have chosen to be bound. The purpose of the law of contract is to give effect to this expression of party autonomy, that is, the essential freedom of the parties as adults of full capacity to undertake binding obligations and to organize their affairs as they see fit, within the limits of the law and public morality. Taken to its logical conclusion, the will theory postulates an extremely subjective approach to contract. Consensus is the sole basis of contractual liability, with the result that if there is no genuine concurrence of wills, there can be no contract. This, whenever a party is mistaken about a material aspect of the proposed agreement, there is no binding contract, as will be the case if a person signs a contractual document without bothering to read it properly, or with some mental reservation that it is not disclosed to the other party, that is not disclosed. No matter that the other party might reasonably think, in light of this behavior, that a contract has come into existence. In the absence of consensus, there can be no contract. It hardly takes a genius to realize that such an unqualified adherence to the will theory would produce results that are both unfair and economically disastrous. It would be unfair because it fails to protect the reasonable expectation of a party who has relied on the objective appearance of consensus created by the other party's conduct. And it would be economically disastrous because it ignores the need for legal certainty in commercial dealing. Business people must be able to rely on signed documents and other objective indications of consent, knowing that they will be upheld as binding contracts by the courts. If they cannot do so, the commercial activity will grind to a halt. It should come as no surprise, therefore, that few, if any, legal systems follow the will theory without qualification. Some profess to adopt an objective approach to contract, in line with the so-called declaration theory. This theory is the polar opposite of the will theory. According to the declaration theory, the inner wills of the parties are irrelevant. What is important for contract is not what the parties think, but what they say or do, the external manifestations of their wills. The true basis of contract is to be found in the concurring declarations of the parties. In determining whether agreement has been reached, one should adopt a position of detached objectivity, as if one had been a neutral observer listening at the keyhole, or a fly on the wall, while the negotiations were taking place. If judged purely objectively, one party has made an offer that has been unambiguously accepted by the other party. There is a contract, irrespective of what either party actually had in mind at the time. This extremely objective approach to contract would also prove unacceptable in practice, unless qualified. By favoring form over substance, it could rather absurdly result in a contract intended by neither party. It would permit parties to disguise their transactions, for example, dressing up a donation as a sale in order to avoid donations tax. It would preclude a claim for rectification where the contract document fails to reflect the common intention of the parties, and it would leave absolutely no room for a doctrine of mistake in contract law. The fact that one or both of the parties labored under a material misapprehension concerning the nature or contents of the contract would be wholly irrelevant. None of this reflects what courts around the world actually do or permit, without which casts serious doubts on the practical viability of the theory. A compromise theory occupying the middle ground between the other two is the Reliance Theory. In terms of this theory, the basis of contract is to be found in detrimental reliance on the appearance of agreement, or in simpler terms, in the reasonable belief in the existence of consensus induced by the conduct of the other party. This, for example, where A signs a document that unambiguously sets out the terms on which B is prepared to do business with A, she will in most cases create in B's mind the reasonable impression that she has agreed to B's terms, and B will be entitled to rely on that impression. Therefore, if A is mistaken about the contents of the document that she has signed, B will be able to enforce it as a contract if his belief in the existence of consensus was reasonable in the circumstances. The reliance theory thus protects a party's reasonable expectation of contract. To the extent that it does so in the absence of consensus, it too represents an objective approach to contract. However, the upholding of the objective appearance of agreement is less absolute than under the declaration theory, since A can escape liability on the grounds of material mistake in circumstances where B's reliance on that objective appearance is unreasonable. Most people would readily accept that it is right to uphold a contract in circumstances such as these. To suggest, however, that reliance is the only basis of contract, as some writers would seem to have it, is another matter altogether. Cases of dissensus are the exception rather than the norm, and where the parties have reached genuine consensus, it seems somewhat artificial to base the contract on reliance rather than the common intention to be bound. The reliance theory should thus be seen as a supplement to the will theory, correcting its deficiencies and affording an alternative basis for contract in circumstances where the minds of the parties have not truly met. This is the approach currently favored by our law and is discussed further below. Then you can just study table 1.2, theories of contract, just a little summary. Okay, 1.7.5, approach to contract, subjective or objective. South African law, with its roots in Roman Dutch law but strongly influenced by English law, has since the earliest times vacillated between a subjective and an objective approach to contract. As late as 1958, the Appellate Division could say that our law follows a generally objective approach to the creation of contracts. However, more recent pronouncements of that court suggest that our approach is fundamentally subjective, though tempered by objective considerations in cases of dissensus. The Roman Dutch writers adopted a subjective approach to contract formation, in line with the general trend in Europe at the time. This was hardly surprising in light of the triumph of consensualism with its emphasis on animus contraendi and the need for a concursus animorum, or meeting of the minds. To what extent the writers were prepared to protect a reasonable reliance on the appearance of contract is not clear. English law, by contrast, has always preferred a more objective approach on the grounds of the intent of man cannot be tried, for the devil himself knows not the intent of man. For a while in the 19th century, under the influence of continental jurists such as Pothier and Savigny, There was some flirtation with the world theory and the notion of consensus ad idem. But then came the famous case of Smith and Hughes, which left no doubt that the English courts would protect a reasonable expectation of contract in the absence of true agreement. After declaring that if parties are not ad idem, there is no contract, unless the circumstances are such as to preclude one of the parties from denying that he has agreed to the terms of the other. Blackburn said that the rule of law was as follows. If whatever a man's real intention may be, he so conducts himself with himself that a reasonable man would believe that he was assenting to the terms proposed by the other party, and that other party upon that belief enters into the contract with him. The man thus conducting himself would be equally bound as if he had intended to agree to the other party's terms. This meant that in the absence of true mutual assent to the proposed terms, a contract might nonetheless be founded upon what was termed quasi-mutual assent, a doctrine that clearly has much in common with estoppel and reflects adherence to the Reliance Theory of Contract. English writers today are generally scornful of the world theory as a relic of 19th century thinking. Although some seem to favor the declaration theory, the general approach of English law seems more in line with the Reliance Theory. The South African courts, as stated earlier, have over the years vacillated between these different approaches. The earliest cases, naturally enough, followed the Roman Dutch writers in suggesting that there could be no contract in the absence of consensus. But when the matter arose for crisp decision in Peters and Co. versus Solomon, the appellate division chose to adopt the English approach, offered to pay B's debt to C, believing the amount in question to be £345 when it was actually £490. C accepted the offer in good faith, not realizing that A was mistaken as to the amount. The court upheld C's claim for the full amount, saying, "When a man makes an offer in plain and unambiguous language, which is understood in its ordinary sense by the person to whom it is addressed, and accepted by him bona fide in that sense, then there is a concluded contract. Any unexpressed reservations hidden in the mind of the promiser are in such circumstances irrelevant. He cannot be heard to say that he meant his promise to be subject to a condition which he omitted to mention, and of which the other party is unaware." The influence of Smith and Hughes is readily apparent in this case. Indeed, the famous Blackburn dictum was thereafter frequently quoted with approval by South African judges, leading to a general belief that our approach to contract was fundamentally objective. This belief was strongly reinforced by the following statement of vessels in South African Railways and Harbours versus National Bank of South Africa Limited. The law does not concern itself with the working of the minds of parties to a contract, but with the external manifestations of their minds. Even therefore, if from a philosophical standpoint the minds of the parties do not meet, yet, if by their acts their minds seem to have met, the law will, where fraud is not alleged, look to their acts and assume that their minds did meet, and that they contracted in accordance with what the parties purport to accept as a record of their agreement. On the face of it, this dictum seems to be an unequivocal affirmation of the declaration theory, but Wessels could hardly have intended his words to be understood as such, for it would be manifestly false to state that under South African law the subjective intentions of the parties to a contract are without relevance. This, by way of example, our law does permit escape from a contract on the grounds of justifiable mistake. It does entertain claims for rectification of contractual documents that incorrectly reflects the parties' common intention. It will strip away the disguise and follow the true intention of the parties to a simulated transaction. It recognizes the importance of animus contrahendi in a variety of contexts, and where the parties have used words in a specialized sense understood by both of them, the court will follow their intention rather than the objective meaning of the words when interpreting the contract. That the vessel's dictum is not to be taken too seriously was confirmed by the Appellate Division in Sambo Nasionale Bouvereniging versus Friedman, the first in a series of cases in which that court, and particularly Janssen, began to reassert that the true basis of contractual liability in our law is not the objective approach of the English law, but is, save in cases where the Reliance Theory is applied, the real consensus of the parties. The point of departure then testing for the existence of a contract, said Janssen, is the will theory, but in cases of dissensus, the shortcomings of that theory are corrected by an application of the Reliance Theory, more particularly in the form of the principle enunciated by Blackburn in Smith versus Hughes. The decision in Steyn versus LSA Motors Limited illustrates that this is now the accepted approach of our law. Steyn, an amateur golfer, participated in a golf tournament that was both open to amateurs and professionals. Next to the 17th hole, there was on display a new car and alongside it a board proclaiming Hole-in-One prize sponsored by LSA Motors. Steyn duly scored a hole-in-one, but the sponsor refused to give him the car on the grounds that the prize had only been intended for professional golfers. In the litigation that followed, it became plain that Small, the representative of the defendant, had never intended to make any offer to an amateur such as Steyn, and that there was accordingly no consensus between the parties. Steyn tried to brush aside this fact with the argument that was important was not Small's intention, but rather what was stated on the advertising board. The court rejected this argument, reasoning as follows. The argument is fundamentally fallacious inasmuch as it treats Small's subjective intention as irrelevant and postulates the outward manifestation of his intention as the sole and conclusive touchstone of the respondent's contractual liability. That is contrary to legal principle. Where it is shown that the offerer's true intention differed from his expressed intention, the outward appearance of agreement flowing from the offeree's acceptance of the offer as it stands does not in itself or necessarily result in contractual liability, nor is it in itself decisive that the offeree accepted the offer in reliance upon the offerer's implicit representation that the offer correctly reflected his intention. Remaining for consideration is the further and crucial question whether a reasonable man in the position of the offeree would have accepted the offer in the belief that it represented the true intention of the offerer. In accordance with the objective criterion formulated long ago with the classic dictum of Blackburn in Smith versus Hughes, only if this test is satisfied can the offerer be held contractually liable. In the light of all the evidence, the court held that a reasonable person in Steyn's position would have realized that the offer was open only to professionals, and accordingly that he had no contractual claim to the car. 1.7.6 Dual basis of contract in modern law. What emerges from all this is that there are two bases on which to establish a contract in modern South African law: consensus and reasonable reliance. The primary basis is consensus. When seeking to determine whether a contract has been formed, one must ascertain whether the minds of the parties actually met. The point of departure is the will theory, and the approach is essentially subjective. If the conclusion is that consensus was reached, that ends the inquiry. One need not look for any other reason to hold the parties bound. If, on the other hand, the conclusion is that the minds of the parties never truly met, the inquiry has to go one step further. One must then ask whether either party, by their words or conduct, led the other party into the reasonable belief that consensus had been reached. If so, the contract will be upheld on the secondary basis of reasonable reliance. In the absence of true mutual assent, a contract can be founded on quasi-mutual assent. This is because our approach to contract is not wholly subjective. It is tempered by objective considerations born of a desire to protect reasonable expectations induced by the other party. The world theory may be the point of departure, but in cases of dissensus, it is tempered by an application of the Reliance Theory. Insistence that profess to adopt an objective approach to contract, like English law, it is probably correct to say that the point of departure is the declaration theory, and that in appropriate cases, such as where escape from the contract is permitted on grounds of mistake, the Reliance Theory operates as a corrective to the declaration theory. Therefore, whether a particular system proceeds from a subjective or an objective premise in cases of dissensus, a more moderate position will be adopted than is suggested by either premise. The Reliance Theory occupies that moderate ground between the two extremes represented by the will and declaration theories. 1.7.7 Proving the existence of contract. The onus of proving the existence of a contract rests on the person who alleges that the contract exists. In light of what has just been discussed, the onus will be discharged by adducing evidence of either consensus or reasonable reliance on the appearance of consensus. In this regard, one must take care not to confuse that which must be proved, frequently a subjective state of mind, with the means of proving it, objective evidence indicating that state of mind. The fact that a party must inevitably rely on objective evidence to prove a subjective state of mind does not mean that the approach to contract must inevitably be an objective one. Assume that A sues B on a contract and that B denies the existence of the contract. In order to prove that the parties reached agreement, A will adduce objective evidence of the agreement in the form of declarations made by the parties. Usually, this will entail handing in as evidence a document signed by both parties. B's signature apprehended to the document serves as prima facie proof that B agreed to the terms reflected in the document. The evidentiary burden this shifts to B to show that, despite the objective appearance of agreement, no consensus was reached. B might do this by proving, for example, that she was mistaken about the contents of the document when she signed it. If the court believes her on this point, the primary basis of contract is missing, and if A's claim is to succeed, he must then prove reasonable reliance on the appearance of the agreement. In most cases, the signed document will serve as prima facie proof not only of consensus but also of reasonable reliance, because it will usually be reasonable to rely on a person's signature as indicating consent. Ultimately, therefore, the evidentiary burden will rest on B to prove that A's belief in the existence of consensus was unreasonable in the circumstances. She might do, for example, by leading evidence to show that A knew she was mistaken, or that A ought to have been aware of this possibility, because the document was potentially misleading, a trap for the unwary. 1.8 Cornerstones of Contract. By now, it will be obvious that consensus and reliance are fundamental concepts in the modern law of contract. Other fundamental ideas include the following. First, the freedom of contract, the idea that people are free to decide whether, with whom, and on what terms to contract. Party autonomy. Secondly, sanctity of contract. The idea that contracts freely and seriously entered into must be honored and, if necessary, enforced by the courts. Pacta sunt servanda. Thirdly, good faith. The idea that parties to a contract should behave honestly and fairly in dealings with one another. And lastly, privity of contract. The idea that a contract creates rights and duties only for the parties to the agreement and not for third persons. Whereas consensus and reliance are the technical basis upon which contractual liability is founded, these other concepts are more in the nature of values that inform the law of contract and provide its ideological underpinning. It is important to appreciate that at the outset that there is some competition between these underlying values, and that this competition produces tensions that run throughout the whole body of contract. Before considering this competition, it might be worthwhile to first reflect on the goals of contract law. And then the pause for reflection. What are the aims of contract law? What purposes are served by having this elaborate structure of detailed rules and principles governing when people are bound by their undertakings to one another? Consider whether the following goals or combination are important. First, to ensure that people keep their promises as a matter of honor and morality in society. Secondly, to promote legal and commercial certainty by providing a framework within which persons can safely transact and conduct business, secure in the knowledge that agreements seriously entered into will be enforced. Thirdly, to promote fairness and reasonableness in contractual dealings by imposing standards that encourage good commercial behavior and that discourage chicanery and overreaching, and or lastly to provide a workable system of rules that will encourage private enterprise and underpin the operation of the free market economy. And then that's the end of the pause for reflection. 1.8.1 The goals of contract. In a simple economy, goods and services are exchanged through barter or immediate payment in cash, and the role of contract is small. However, as soon as lags are introduced between the undertaking and the performance of obligations, the parties to a transaction must inevitably begin to rely on their reciprocal promises to perform at a future date. This greatly increases the risk of transaction and requires a certain degree of trust between the parties. But trust alone is not sufficient. If commercial enterprise is to take off on any significant scale, the parties must know that should either of them fail to honor their promise, the other might invoke the assistance of the law to hold them to the agreement. The law must therefore provide mechanisms for the enforcement of promises, or for the payment of appropriate compensation when they are broken. At the same time, the state should and will lend its muscle for the enforcement of private bargains only if satisfied that it is fair and reasonable to do so in the circumstances. It must accordingly regulate to some extent the conclusion and performance of agreements, to ensure that there is no overreaching or coercion, and that the parties conduct themselves in an appropriate manner. The function of contract is this not merely to ensure that people keep their promises, as a matter of honor or morality. Rather, it is to provide a legal framework within which people can transact business and exchange resources secure in the knowledge that, provided that they act honestly and fairly and follow the right procedures where appropriate, the law will uphold their agreements, if necessary, enforce them. As such, the law of contract underpins private enterprise and regulates it in the interest of fair dealing. 1.8.2 Competing values in the law of contract. The law of contract is accordingly concerned not only with the sanctity of contract, but also with fairness in contract dealings. To a large extent, as already noted, these goals or values are in competition with one another, and as commentators have pointed out, finding the right balance between them is one of the most intractable problems facing modern contract law. It goes without saying that the balance struck must be consistent with constitutional values, and should serve to promote the spirit, purport, and objects of the Bill of Rights. The notion of sanctity of contract goes hand in hand with freedom of contract, and with it the philosophies of individualism and economic liberalism. Provided they have the requisite contractual capacity, parties should be free to determine the contents of their contracts, free of external control, and the role of the state should by large be limited to enforcing agreements that have been freely concluded. The knowledge that contracts freely and properly entered into will be enforced by the courts promotes legal and commercial certainty, an essential requirement for a flourishing free market economy. To the same end, the law should be stated in clear and precise rules, since vague, open-ended standards invite uncertainty. On the other hand, a concern for fairness and good faith in contractual relations implies a degree of social control over the private business of contracting, and reflects a more communitarian approach to contract. While parties might enjoy considerable freedom in determining the contents of their contracts, they cannot legitimately expect the courts to enforce provisions that are offensive to law, morals, public policy, or to broad community notions of what is fair and reasonable. The law of contract should accordingly import open-ended standards like good faith and reasonableness in order to give judges sufficient flexibility to ensure justice in each particular case. The tension between these competing goals of contract law is quite evident. The pursuit of individual freedom of contract or of certainty of contractual relations will come at a price in terms of contractual justice, and vice versa. Every time a court enforces an unreasonably harsh contractual provision, a price is paid in terms of the ordinary person's sense of what justice requires. Conversely, every time a court allows a party to escape liability under what was thought to be a binding contract, a price is paid in terms of legal and commercial certainty. The more the law is framed in terms of rigid rules, the less scope there is for judicial maneuvering in the interests of justice. The more it is framed in terms of flexible standards, the less certain will be the outcome of any particular case. Clearly, as in other areas of law, there is a need here for a trade-off between two desirable goals. Where the balance ought to be struck requires a value judgment that will differ from person to person and from community to community, and ideas in this regard will change over time. Historically, our law has tended to favor sanctity of contract over considerations of good faith and equity. But as we shall see, the pendulum is now swinging in the opposite direction, under the influence of the Constitution. 1.8.3 Freedom and Sanctity of Contract. The twin notions of freedom and sanctity of contract are rooted in the political and economic philosophies of laissez-faire, liberalism, and individualism, which reached their peak in the late 19th century. They reflect a concept of contract and a body of legal doctrine that English writers generally refer to as the classical law of contract. By freedom of contract is meant that the parties are free to decide whether or not to contract, with whom to contract, and on what terms to contract. The creation of a contract is the result of a free choice, without external interference, and in the process of contracting, the parties are sovereign. Accordingly, once a court is satisfied that the contract is freely entered into and that its terms are not immoral, illegal, or contrary to public interests, it should uphold and, if necessary, enforce the contract. Pacta sunt servanda. In the famous words of an English judge, which have often been quoted with approval by the South African courts, if there is one thing which, more than other, public policy requires, it is that men of full age and competent understanding shall have the utmost liberty of contracting, and that their contracts, when entered into freely and voluntarily, shall be held sacred and enforced by courts of justice. The dominant features of this classical model of contract law are the following. First, freedom and autonomy of the parties. In terms of laissez-faire economic theory, the license given to the parties to achieve their own desired results will maximize their own and society's collective wealth. Secondly, minimal state intervention. Regulation of contracting should be kept to a minimum, with the role of the law and the courts being merely to recognize and to enforce the agreement reached by the parties themselves. Contracting is like a game of cricket, with the judge's role being equivalent to that of a neutral umpire who ensures that the game is played according to the rules, but who never personally participates in the game itself. Provided the rules are fair and the parties abide them, the outcome will be fair. The law's role is this to ensure procedural rather than substantive fairness in contract. Thirdly, a preference for clear and certain rules rather than open-ended standards. In the interests of commercial certainty, the rules should be clear and simple, in line with business expectations and with little room for the exercise of judicial discretion. Fourth, interested individualism. Contracting is an inherently adversarial process in which each party seeks to maximize his or her own benefit, without undue regard for the interests of the other party. Fifth, assumed fairness of the exchange. The agreement reached is the result of a bargain struck after negotiations during which each party looked after their own interests. And number 6, a discrete event. A contract is, by large, an once-off event, rather than a long-term relationship involving mutual trust and cooperation between parties. The idea of freedom of contract is deeply ingrained in our society, so much so that we tend to take it for granted, but there is nothing inevitable about it. In early societies, the role of contract was small because obligations were generally thought to arise from custom and status, rather than from the existence of free choice. In collectivist societies, the production and distribution of goods and services is to a large extent achieved through central planning rather than contract. Even in Western democratic societies, the idea of freedom of contract is today under considerable pressure for reasons that we will now briefly mention. The classical model of contract is based on the assumption that contracting parties generally do have a real freedom of choice whether, with whom, and on what terms to contract. This assumption in turn is based on a number of other assumptions, such as that, first, the parties enjoy more or less equal bargaining power. Secondly, there is perfect or near perfect competition in the market. And lastly, the parties actually negotiate the terms of their contracts. It is now widely recognized that in very many everyday situations, these assumptions are simply not correct. Accordingly, the whole elaborate structure of classical contract law rests on rather shaky foundations. Social and economic pressures frequently leave people with little choice whether or not to enter into contract. Equality of bargaining power is the exception rather than the norm. Markets dominated by a few large corporations or entities often leave little room for choice of one's contracting partner, and negotiation of the terms of a contract occurs only in a tiny fraction of cases. Even in respect of basic matters such as price, usually a party has little choice but to accept the standard terms proposed by the other. These observations are particularly true in regard to consumer contracts, as opposed to those concluded between large commercial concerns, where the parties are often represented by legal advisors. Even in the 19th century, the classical model represented a rather idealistic and unrealistic picture of contract as experienced by ordinary people, and this is certainly more so today. Circumstances have changed quite dramatically over the course of the last century, calling into question some of the most basic tenets of contract law and generating pressures for reform. Among the many developments responsible for this challenge to traditional contract theory may be mentioned. First, the ever-increasing rule of standardized terms and forms for concluding contracts. Secondly, the advent of the welfare state, with considerable government intervention in markets to alleviate poverty and some of the hardship caused by unbridled capitalism. Third, the rise of the consumer protection movement as a political force in most Western society. Fourth, the growing importance attached to human rights as manifested in South Africa by the enactment of the Constitution. And number 5, the concomitant emphasis upon controlling the exercise of power and ensuring fairness in contractual relations. Of all these related developments, none has done more to undermine genuine freedom of contract than the emergence of the standard form contract, characterized by its take it or leave it nature. In an age of mass production and mass consumption of goods and services, considerations of costs and convenience have necessarily led to mass contracting on terms and conditions that are standardized and simply imposed on the other party, usually a consumer. It has been estimated that probably 95% of all transactions today are concluded in this manner. The individual negotiation of contracts is expensive in terms of both time and money, and so most businesses operate on the basis of documents drawn up for them by their legal advisors and not prepared to consider any variation of the standard terms. Systems are set up so that transactions can be concluded quickly and efficiently, and often without the need for any interaction between the contracting parties. For example, buying a chocolate bar from a machine, for example, or parking a car in a public garage. There is nothing inherently wrong in contracting in this manner. Consider the inconvenience that it would be caused if each person entering a soccer stadium felt free to bargain the terms of the deal. However, it is open to abuse, in that the party who draws up the contract or creates the system can impose unreasonable terms upon the other. At the stroke of a pen, or more likely the painting of a sign on a wall, the consumer can be deprived of valuable common law rights, particularly the rights to sue for damage caused by negligence. Think, for example, the ubiquitous parking at own risk signs that are so often encountered. These and other such exemption clauses have caused headaches for judges around the world. The general reaction of the courts has been to interpret the clauses as narrowly and restrictively as possible, on the fictitious basis that the parties could never have intended to exclude liability for negligence. Lord Denning frankly admitted as much in this memorable passage from an English case. None of you nowadays will remember the trouble we had when I was called to the bar with exemption clauses. They were printed in small print on the back of tickets and order forms and invoices. They were contained in catalogues or timetables. They were held to be binding on any person who took them without objection. No one ever did object. He never read them or knew what was in them. No matter how unreasonable they were, he was bound. All this was done in the name of freedom of contract. But the freedom was on the side of the big concern which had the use of the printing press. It was a bleak winter for our law of contract. Faced with this abuse of power by the strong against the weak, by the use of the small print of the conditions, the judges did what they could to put a curb on it. They still had before them the idol, freedom of contract. They still knelt down and worshipped it, but they concealed under their cloaks a secret weapon. They used it to stab the idol in the back. This weapon was called the true construction of the contract. They used it with great skill and ingenuity. They used it so as to depart from the natural meaning of the words of the exemption clause and to put on them a strained and unnatural construction. In case after case, they said that the words were not strong enough to give the big concern exemption from liability, or that in the circumstances the big concern was not entitled to rely on the exemption clause. But when the clause itself was itself reasonable and gave rise to a reasonable result, the judges upheld it. And at any rate, when the clause did not exclude liability entirely, but only limited it to a reasonable amount. As Lord Denning went on to say, the problem was ultimately solved in England by the enactment of the Unfair Contract Terms Act 1977. Calls for similar legislative intervention in South Africa led to an investigation by the Law Commission, which in its final report on the matter proposed the enactment of legislation giving the courts wide discretionary powers to control unfairness in contractual relations. The proposal has never been implemented, at least not in the general form proposed, although, as is discussed below, the Consumer Protection Act of 2008, CPA, does contain provisions regulating unfair or unreasonable terms in consumer contracts. The proposal met with resistance from the legal and commercial fraternities who feared that enactment of the proposed legislation would introduce an unacceptable level of uncertainty into commercial dealings. The general feeling in legal circles was that a better and more nuanced solution to the age-old problem of unfairness in contract could be found through a careful and judicious development of the existing common law doctrines and devices. The device that most readily sprang to mind was the principle of good faith, which had long been said to underlie and inform all contractual relations, and to which our attention must now turn. And now for the pause of reflection. The Constitutional Court's view on freedom of contract. In Barkhuizen versus Napier, Nkobo, for a majority of the Constitutional Court, described pacta sunt servanda as a profoundly moral principle on which the coherence of any society relies. He said also that the principle gives effect to the central constitutional values of freedom and dignity. Self-autonomy, or the ability to regulate one's own affairs, even to one's own detriment, is the very essence of freedom and a vital part of dignity. On the other hand, warned the learned judges, the general rule that agreements must be honored cannot apply to agreements that are immoral or contrary to public policy, as discerned from the values embodied in the Constitution and in particularly the Bill of Rights. Unfair or unreasonable contractual provisions would therefore generally not be enforced. Moreover, had to address the question whether imbalances between the parties prevented them from ever reaching true agreement. The minority judgment of Sachs gives a valuable and erudite account of the challenges presented worldwide by the standard form contracts of adhesion, but leaves open for future consideration the question whether onerous and unilaterally imposed terms in such contracts should in general be regarded as offensive to public policy in our new constitutional dispensation. Okay, and that is the end of our pause for reflection. 1.8.4 Good faith, equity, and public policy in contract. The concept of good faith or bona fide has deep roots in our legal system. It played a significant role in the development of the Roman law of contract and helped breathe an equitable spirit into the body of the civil law throughout the course of the ensuing centuries. In recent times, there has been much debate about the role it might play in the modern law of contract. As a counterweight to the dominant idea of freedom of contract and as a means of developing a doctrine of unconscionability to ensure greater fairness of contractual relations. Roman law, it will be recalled, recognized only a limited number of contract types, which were classed as either stricti iuris or bona fide, according to the procedural form of actions that govern disputes arising from them. In relation to the older and more formal stricti iuris or iuris contracts, good faith originally played almost no role at all. Provided the correct form had been observed, the contract was binding, even if induced by fraud. To counteract the injustice that this caused, the praetor introduced the equitable defense of bad faith, which could take two forms. The exceptio doli specialis could be raised if the contract had been induced by fraud, while the exceptio duelli generalis was available in circumstances where the very act of bringing the action constituted an act of bad faith. For example, where the plaintiff had informally promised by way of a non-binding pactum that he would not enforce the contract before a certain date, and then went back on his word. The effect of this innovation was to give the judge an equitable discretion to decide the matter before him in accordance with what appeared to be fair and reasonable. There was no need for the exceptio duelli in relation to the matter in the relation to the much later and more flexible bona fide contracts, such as sale and lease, because, as their very name implies, the judge was in any event required to decide disputes arising out of such contracts in accordance with the dictates of good faith. In post-classical Roman times, when the system of civil procedure changed, the distinction between stricti iuris and bona fide contracts lost much of its significance. However, it was only in the 18th century that the Roman Dutch writers clearly stated for the first time that all contracts were now based on consent and were therefore bona fide in character. With the demise of the stricti iuris contracts, there was no longer any room for the technical defense of exceptio duelli, but the idea of good faith as an informing principle of the law of contract lived on. The parties to a contract were required to conduct themselves in a manner consistent with good faith. This, when a defendant now raised the defense of exceptio duelli, he or she was merely alleging that the plaintiff's behavior fell short of this standard. To what extent, if at all, the existence of this defense gave the judge an equitable discretion to depart from the strict requirements of the law in any particular case remains somewhat unclear. In South Africa, the exceptio duelli generalis surfaced in the law reports in the late 19th century, when it was used by the courts, controversially at first, to import a number of equitable doctrines from English law. For example, estoppel, rectification, and the right to rescind a contract induced by innocent misrepresentation. Whether the exceptio could be raised as a defense in its own right to a claim that was technically good in law, but unconscionable in the particular circumstances of the case, was a highly disputed question. On a number of occasions, the appellate division was prepared to assume that such a defense was still possible in modern law. At any rate, in circumstances where enforcement of a plaintiff's remedy would cause some inequity and would amount to unconscionable conduct on his part, The question was only settled in 1988 when a majority of the Appellate Division finally decided in Bank of Lisbon and South Africa Limited versus de Ornelas that the Exceptio Duelli Generalis had never been received into Roman Dutch law and afforded no grounds for the recognition of a substantive defence based on equity in modern South African law. The decision caused general dismay, particularly in academic circles. But while it put an end to the lingering afterlife of the Exceptio Duelli in South Africa, it also sparked an urgent debate about the need to develop some other means of ensuring greater fairness in the operation of the law of contract. Legislative intervention was always a possibility, of course, and was being investigated by the Law Commission. The focus of academic attention, however, fell on the common law principle of good faith, which was generally considered to have survived the decision in Bank of Lisbon. The question arose: was good faith a free-floating principle that permitted a court to intervene directly in contractual relations, or did it operate only indirectly through established common law rules and doctrines, such as those relating to public policy and the legality of contracts? In Susfin Proprietary Limited versus Beekes, decided barely 6 months after Bank of Lisbon, the Appellate Division appeared to prefer the latter view. The respondent doctor had entered into an agreement with the appellant finance company, in terms of which he placed the company in immediate and effective control of his present and future earnings, and rendered himself powerless to bring the situation to an end. Such an agreement, said the court, was clearly unconscionable and incompatible with the public interest. Although public policy generally favored the utmost freedom of contract, a relevant and not unimportant consideration was that public policy should probably take into account the doing of simple justice between man and man. Various clauses of the agreement were so unconscionable, so grossly exploitative, and offended against the morals of the public to such an extent that they could not be countenanced, and the whole agreement was accordingly struck down on the grounds of public policy. It should be noted that the court in Susfin was silent on the principle of good faith, but one interpretation of the decision was that it allowed that principle, which had been dealt such a body blow in Bank of Lisbon, to reassert its influence in contract through the requirements of legality. Good faith, it was argued, could better serve as a counterweight, in scales of public policy, to the dominant principle of individual autonomy than the rather unsophisticated notion of simple justice between man and man. On this reasoning, the public interest in freedom and sanctity of contract needed to be balanced against the public interest in the preservation of good faith in contractual relations, and the unreasonable and one-sided promotion of one's own interest at the expense of another might, in extreme cases, infringe the principle of good faith to such a degree as to outweigh the public interest in the strict enforcement of contracts. This interpretation of Susfin received a powerful support from Olivier in his concurring minority judgment in Eerste Nasionale Bank van Suidelike Afrika BPK versus Seyman. In declining to enforce a deed of suretyship signed by a frail 85-year-old woman in favor of a company owned by her son, on the grounds that the bank should either have advised her to get independent legal advice before committing herself, or should itself have explained to her the implications of what she was doing. The learned judge emphasized the close link between good faith and public policy. The function of good faith, he said, is to give expression to the community's sense of what is fair, just, and reasonable, and the majority decision in the Bank of Lisbon should not be read as denying it this role. Then, shortly thereafter the Supreme Court of Appeal made a passing reference to this of this judgment of Olivier in a matter that appeared to express its approval of his general approach to the question of public policy, bona fides, and contractual equity. Certain judges in the Cape interpreted this dictum as our highest court, giving the green light in the direction of the development of a concept of good faith in our law of contract, which would render the body of contract law congruent with the values of our constitutional community. And then there's a pause for reflection. The exact role that good faith plays in contract remained a matter for debate. Hardly anyone doubted that parties were required to negotiate and perform their contracts in good faith, but the precise nature and scope of the requirement was the subject of much debate. Was good faith an independent principle that courts could employ directly to justify intervention in contractual relationships by declining to enforce terms that were considered to be unfair or unreasonable, or was it merely an ethical value underlying the law of contract? Similar in nature and effect to concepts like fairness, justice, and reasonableness. And what exactly did it require from contracting parties? Merely that they should conduct themselves honestly, or beyond that, that they should afford a measure of recognition and respect to the legitimate interests pursued by the other party in entering the contract. That's the end of the pause for reflection. In a trio of subsequent cases, commencing with Brisley versus Trotsky and involving some of the most controversial doctrines of contract law, the Supreme Court of Appeal made it abundantly clear that this interpretation of its stance on the role of good faith and equity in contract was incorrect. Its view on the matter was summed up as follows in York. Although abstract values such as good faith, reasonableness, and fairness are fundamental to our law of contract, they do not constitute independent substantive rules that courts can employ to intervene in contractual relationships. These abstract values perform creative, informative, and controlling functions through established rules of the law of contract. They cannot be acted upon by the courts directly. Acceptance of the notion that judges can refuse to enforce a contractual provision merely because it offends their personal sense of fairness and equity will give rise to legal and commercial uncertainty. After all, it has been said that fairness and justice, like beauty, often lie in the eye of the beholder. Nor could a court seek refuge in the shadow of the Constitution, for neither the Constitution nor the value system it embodies gives the court a general jurisdiction to invalidate contracts on the basis of judicially perceived notions of unjustness or to determine their enforceability on the basis of imprecise notions of good faith. On the contrary, the Constitution's values of dignity and equality and freedom require that the courts approach their task of striking down contracts or declining to enforce them with perceptive restraint. One of the reasons is that contractual autonomy is part of freedom. Shorn of its obscene excesses, contractual autonomy informs also the constitutional value of dignity. The Constitution requires that its values be employed to achieve a careful balance between the acceptable excesses of contractual freedom and securing a framework within which the ability to contract enhances rather than diminishes our self-respect and dignity. This conservative stance adopted by the Supreme Court of Appeal attracted strong criticism, and the question inevitably arose how the Constitutional Court would address this issue of fairness in contract when the opportunity presented itself. The question was largely answered in the seminal case of Barkhuizen versus Napier, which concerned the constitutionality of a time limitation clause in a short-term insurance policy. The clause purported to prevent the insured party from instituting legal action against the insurer if summons was not issued within 90 days of the insurance repudiation of the claim. It was attacked on two grounds: that it was unconstitutional because it violated the applicant's rights under Section 34 of the Constitution to seek judicial redress, and that it was contrary to public policy in that it operated in an unreasonably harsh and unfair manner against the applicant. Although the attack ultimately failed for lack of evidence that the enforcement of the clause against the applicant would be unjust, the approach of the Constitutional Court to the issue of unfair contract terms was marked different from the Supreme Court of Appeal, Delivering the judgment of the majority, Nkobu said that the proper approach to constitutional challenges to contractual terms is to determine whether the term challenged is contrary to public policy, as evidenced by the values that underlie our constitutional democracy and which find expression in the Bill of Rights. Public policy, he said, represents the legal convictions or general sense of justice of the community, the boni mores and the values held most dear by our society. It takes into account the necessity to do simple justice between individuals, and it is informed by the concept of Ubuntu. Public policy imports the notions of fairness, justice, and reasonableness. Accordingly, while public policy endorses freedom and sanctity of contract, it would also preclude the enforcement of a contractual term in circumstances where such enforcement would be unjust or unreasonable. To the extent that the Supreme Court of Appeal had suggested otherwise, when it said that the mere fact that a term is unfair or might operate harshly does not in itself lead to the conclusion that it offends against constitutional principle, that dictum could not be supported. In determining the issue of fairness, said Nkobu, two questions had to be asked. The first was directed at the objective terms of the contract in question. Was the clause in question so manifestly unreasonable on its face as to be inconsistent with public policy? This inquiry involved weighing up the notion of sanctity of contract against the other competing values or considerations, such as in this case the right to seek judicial redress, but with due regard also the relative situation of the contracting parties, in particular their relative bargaining powers. If the clause itself was reasonable, the second question arose: should it be enforced in light of the circumstances that prevented compliance with the clause? Moseneke and Sachs, in their dissenting opinions, preferred a more objective approach to the public policy inquiry. Public policy cannot be determined by the behest of idiosyncrasies of individual contracting parties, but otherwise expressed no disagreement with the general approach of making fairness and reasonableness the focus of public policy inquiry. This approach, it will be noted, leaves little room for a distant role to be played by the concept of good faith, which goes some way to explaining why not much is said about the concept in any of the judgments. Nkobu did question whether the limited role assigned to good faith in cases such as Brisley and Drotsky is appropriate in the new constitutional dispensation, but found it unnecessary to address that issue. Quite how Barkhuizen would be interpreted and applied in subsequent cases became the burning issue of the day, since the decision clearly had the potential to bring about radical change in the law of contract. Some commentators suggested that it amounted to a virtual resurrection of the exceptio duelli generalis in interpretation that seemed vindicated shortly thereafter when, at first instance in Bredenkamp versus Standard Bank of South Africa Limited, Jobby regarded Barkhuizen as being authority for the proposition that the party to a contract cannot first impose a term on another party if it would, if applied, operate unfairly, and secondly, cannot enforce a term in a manner that is unfair. On this basis, the court granted an interim interdict restraining the bank from exercising its contractual right to close a customer's bank accounts and terminate the agreements underlying them on reasonable notice, holding that this power had to be exercised fairly and for good cause, notwithstanding a provision in the contract allowing the bank to close the account for any reason. However, when Bredenkamp's case came before it on appeal, the Supreme Court of Appeal empathetically rejected the idea of an overarching requirement of fairness in the law of contract, declaring that Barkhuizen neither held nor purported to hold that the enforcement of a valid contractual term must be fair and reasonable, even if no public policy consideration found in the Constitution or elsewhere is implicated. Fairness is not a freestanding requirement for the exercise of a contractual right. Despite criticism, the court has remained steadfast in its view, maintaining in a number of subsequent cases that unless and until the Constitutional Court holds otherwise, a court cannot refuse to give effect to the implementation of a contract simply because that implementation is regarded by the individual judge to be unreasonable and unfair. How is the approach of the Supreme Court of Appeal to be reconciled with the unambiguous statement in Barkhuizen that public policy would preclude the enforcement of a contractual term if its enforcement would be unjust or unfair? One possible answer is that Barkhuizen must be read in context. The case concerned a contractual term that limited the constitutional right of access to the courts, and it is only in such a case where a constitutional value or principle is implicated that the question of fairness or reasonableness becomes relevant. If the term is so offensive to the values enshrined in the Constitution as to be contrary to public policy, it is devoid of legal effect, and the question of enforcement does not arise. However, even if the term itself is quite innocent, its enforcement in the particular circumstances of the case might serve to limit a constitutional right. In such a case, the court is required to assess at the time of enforcement whether the limitation brought about by the enforcement of the contractual term is fair and reasonable in circumstances. This interpretation of Barkhuizen is consistent with the approach of the courts to the enforcement of agreements in restraint of trade, but is difficult to reconcile with the Supreme Court of Appeal's own previous decision in Sasfin v. Beekes. A better interpretation, perhaps, is that fairness is always one of the factors to be taken into consideration when determining whether enforcement of a term would be contrary to public policy, but it is not an independent requirement for enforcement. That is to say, a court cannot refuse to enforce an otherwise valid term solely on the ground that it would be unfair in the circumstances to do so. Whether the Constitutional Court will agree with this interpretation of Barkhuizen and be content with a more limited role for considerations of fairness in contracts is a question for the future. That seems unlikely in view of the Constitutional Court's pronouncements on the matter in subsequent cases. In Everfresh Market Virginia Proprietary Limited versus ShopRite Checkers Proprietary Limited, the court emphasized the central importance of good faith in our contract law and the desirability of infusing the law of contract with constitutional values, including values of Ubuntu. In Werthoff versus Rich, the court went further, defining the central issue in that case as being whether cancellation of the contract in question for material breach was fair in the circumstances, and this constitutionally compliant. In an unambiguous judgment, the court refused to follow the cancellation on the grounds that it would be a disproportionate penalty for the breach. The fairness of awarding cancellation, said the court, is self-evidently linked to the consequences of doing so. Surprisingly, no mention was made of the Supreme Court of Appeal's decision in Bredenkamp. This distinction between the approaches of the Constitutional Court and the Supreme Court of Appeal is to be regretted. It is the source of some tension between the two courts, as evidenced by the extra-curial writings of some judges of the SCA, and is causing a considerable degree of uncertainty in the legal and commercial worlds. Few people would quibble with the sentiment that the law of contract should be infused with the spirit of good faith or Ubuntu, nor that contract law cannot confine itself to colonial legal tradition alone. As others have pointed out, however, a rule of law based solely on the exercise of judicial discretion and a sense of reasonableness and fairness may be no rule at all. Indeed, it runs counter to the principle of legality and is thus destructive of the rule of law. There is an urgent need for an unequivocal statement by the Constitutional Court clarifying the position. The approach of the Supreme Court of Appeal seems more appropriate in the context of large commercial contracts, but is out of step with that adopted by the legislature in regard to consumer contracts, as we shall now see. 1.9. The Consumer Protection Act 68 of 2008. The Consumer Protection Act, or CPA, which is discussed in greater detail in a subsequent chapter, came fully into force on the 1st of April 2011. It is bound to give a huge impact upon the conduct of business in South Africa, and of greater interest or concern for present purposes upon the law of contract. The primary purpose of the Act, as its name implies, is to protect consumers from exploitation in the marketplace, and to promote their social and economic welfare. More specifically, the Act aims, among other things, to establish a legal framework for the achievement and maintenance of a consumer market that is fair, accessible, efficient, sustainable, and responsible for the benefit of consumers generally. To promote fair business practices and to protect consumers from unconscionable, unjust, or unreasonable business practices. To achieve these objectives, the Act recognizes a number of fundamental consumer rights, including: first, the right to equal treatment in the marketplace; secondly, the right to privacy; thirdly, the right to choose, which covers a host of ancillary rights such as rights to select suppliers, to choose or examine goods and return them, to a cooling off period in certain circumstances, and to cancel advance bookings, reservations, or orders. Fourthly, the right to disclosure and information. Fifthly, the right to fair and responsible marketing. Sixth, the right to fair and honest dealing. Seventh, the right to fair, just, and reasonable terms and conditions. And eighth, the right to fair value, good quality, and safety. These rights are protected and enforced not only through the courts but also through national consumer protection institutions. These include the National Consumer Commission and the National Consumer Tribunal, already established under the National Credit Act. A failure to comply with the provisions of the CPA might attract various sanctions, commencing with compliance notices and leading possibly to the imposition of fines and criminal penalties. Contractual provisions in contravention of the Act may be declared null and void to the extent of non-compliance. The scope of the Act is very wide. It applies to most transactions concluded in the ordinary course of business between suppliers and consumers within South Africa, as well as the promotion of goods and services that could lead to such transactions, and to the goods and services themselves once the transaction has been concluded. A supplier is any person, including a juristic person, trust, or organ of state, who markets, that is, promotes or supplies, any goods or services. A consumer includes not only the end customer or user of goods and services, but also the franchisees and relatively small businesses in the supply chain, with an asset value or annual turnover below the threshold determined by the minister, Presently, that is 2 million rand. The Act does not apply to transaction in terms of which goods or services are promoted or supplied to the state or to a juristic person with an asset value or annual turnover above the prescribed threshold of 2 million rand. Nor does it apply to employment contracts and credit agreements to avoid overlap with other protective legislation, or to transactions specifically exempted by the minister. Of most interest for present purposes are those provisions of the Act dealing with the consumer's right to fair, just, and reasonable terms and conditions. Certain terms or conditions are prohibited outright, with the result that they are void to the extent of non-compliance. These include, first, terms aimed at defeating the purpose and policy of the Act, or misleading the consumer or subjecting the consumer to fraudulent conduct. Secondly, terms that purport to waive or deprive a consumer of rights under the Act or to avoid a supplier's obligations under the Act. Third, a term that purports to limit or exclude the liability of a supplier, or those for whom he or she is responsible, for harm caused by gross negligence. And fourthly, a term that falsely expresses an acknowledgement by the consumer that no warranties or misrepresentations were made in connection with the agreement. Where terms are not prohibited outright, they are subject to a requirement of fairness and reasonableness. This, a supplier must not supply or offer to supply any goods or services, nor require a customer to waive any rights, assume any obligations, or waive any liability of the supplier on terms that are unfair, unreasonable, or unjust. A term is unfair, unreasonable, or unjust if, firstly, it is excessively one-sided in favor of the supplier, or secondly, it is so adverse to the consumer as to be inequitable, or thirdly, it was induced by supplier's false, misleading, or deceptive misrepresentation, or lastly, the existence, nature, and effects of the term was not adequately drawn to the attention of the consumer in a clear and conspicuous manner before the transaction was entered into. One consequence of these provisions is that liability for ordinary but not gross negligence may still be excluded by means of an appropriately worded exemption clause, provided the exclusion is fair and reasonable and that it is adequately drawn to the attention of the consumer before or at the time of entry into the transaction. Then there's a small pause for reflection. Does the CPA go too far in protecting consumers? In many respects, the CPA merely restates protection that is already afforded by the common law. For example, in relation to liability for misrepresentation, duress, and undue influence. In other respects, it goes very much further, affording South African consumers a level of protection that should make them the envy of consumers in most other parts of the world. Organized commerce is concerned with the introduction of strict no-fault liability for defective products, but this is now the norm in many developed societies. Undoubtedly, it will raise the cost of doing business and thereby will lead to some increase in prices, but this is probably a price worth paying for greater protection afforded to consumers. The test for the fairness of contractual terms is in some respects rather circular, being phrased in terms of inequity. This will allow courts a large measure of discretion in deciding whether or not to enforce the term against the consumer. Will this discretion give rise to the legal uncertainty and chaos so feared by the Supreme Court of Appeal in Brisley v. Trotsky? Will the level of uncertainty be any greater than that flowing from the decision of the Constitutional Court in Barkhuizen v. Napier? In the light of the court's traditional reluctance to enforce exemption clauses, at least to their full extent, suppliers might have good grounds for fearing that in future in the future, such clauses will afford them little protection against liability for negligence. It may be in their own best interests simply to insure against liability and to pass the costs of this insurance on to consumers. That's the end of the pause for reflection. Point 10. The impact of the Constitution. We consider first the question whether the Constitution applies directly to a contractual dispute between private parties, and thereafter the possible ways in which the Constitution may impact upon the law of contract. When the interim Constitution was first enacted, there was much debate as to whether the Bill of Rights applied only vertically, that is, to relationships between the state and the individual, or also horizontally, that is, to relationships between private persons, as in most contractual situations. And if the Bill of Rights did have horizontal application to purely private relationships, the further question arose: did it apply directly or merely indirectly? By direct application was meant that the litigant could directly invoke a provision of the Bill of Rights to establish a cause of action or a defense to a claim. For example, if a term of contract violated one of the fundamental rights protected by the Constitution, direct application would entail that a party could attack the term simply on that ground, and without reference to any rule of the common law. On the other hand, if the Bill of Rights applied only indirectly on the horizontal plane, then any impact that it might have upon a contractual dispute would have to be achieved through an influence exerted upon the common law of contract. In the example given above, the litigant who attacked the contractual term might argue that because it violated a fundamental constitutional right, the term was contrary to public policy and was thus illegal under the common law. In Duplessis versus de Klerk, the Constitutional Court finally ruled that the interim constitution did apply to relations between private persons on the horizontal plane, but that in general it did so only indirectly and not directly. In the result, a litigant could directly invoke a provision of the Bill of Rights against an organ of state, but not against a private person or entity, unless the dispute concerned the validity of legislation or of an executive act, because that would introduce a vertical element to the dispute. The position under the final Constitution is in some respects less clear. The Supremacy Clause, Section 2, provides, "The Constitution is the supreme law of the Republic. Law or conduct inconsistent with it is invalid, and the obligations imposed by it must be fulfilled." This leaves no room for doubt that all law, including the common law of contract, is subject to constitutional control, a position now confirmed by the Constitutional Court. The validity of all law this depends on its consistency with the provisions of the Constitution and the values that underlie it. Equally clearly, Section 39(2) of the Subsection 2 of the Constitution makes provision for indirect horizontal application of the Bill of Rights. When interpreting any legislation and when developing the common law or customary law, every court, tribunal, or forum must promote the spirit, purport, and objects of the Bill of Rights. The purpose of Section 39, Subsection 2 of the Constitutional Court has said is to ensure that our common law is infused with the values of the Constitution. It imposes an obligation on courts to be alert to the normative framework of the Constitution, and to ensure that the rules of the common law conform to the requirements of the Constitution, not only when some startling new development of the common law is in issue, but in all cases where the incremental development of a common law rule is in issue. The common law of contract is shot through with open-ended concepts such as good faith, public policy, and reasonableness. The malleable standards afford a ready and convenient means of infusing the law of contract with the spirit and values of the Constitution. Okay, then there's a pause for reflection. Developing the common law of contract in line with the Constitution. The obligation of the courts to develop the common law of contract where it is deficient in promoting the Section 39 subsection 2 objectives is a general one, and not purely discretionary. Some commentators appear to believe that the broader constitutional project requires a radical transformation or restructuring of the law of contract. The Constitutional Court, recognizing the need for legal certainty, which is essential for the rule of law, a constitutional value, and that our common law principles contain much of lasting value. That is, age is not necessarily a reason to change. Some of the lessons gained from human experience over the ages are timeless and have passed the logical and moral tests of time. Has recently advocated a more cautious approach, that before a court proceeds to develop the common law, it must A. determine exactly what the common law position is, B. then consider the underlying reasons for it, and C. inquire whether the rule offends the spirit, purport, and object of the Bill of Rights, and this requires development. Furthermore, it must D. consider precisely how the common law could be amended, and E. take into account the wider consequences of the proposed change on that area of law. Moreover, said the court, respect for the principle of separation of powers requires that the major engine for law reform should be the legislature and not the judiciary. That is the end of the pause for reflection. What remains still somewhat unclear is to what extent the Bill of Rights finds direct horizontal application. The answer to that question depends upon the interpretation of the application clause, that is, Section 8, which provides as follows. Section 1, or Subsection 1. The Bill of Rights applies to all law and binds the legislature, the executive, the judiciary, and all organs of state. Number 2. A provision of the Bill of Rights binds a natural or juristic person if and to the extent that it is applicable, taking into account the nature of the right and the nature of any duty imposed by the right. Subsection 3. When applying a provision of the Bill of Rights to a natural or juristic person in terms of subsection 2, a court must in order to give effect to a right in the bill, must apply or, if necessary, develop the common law to the extent that legislation does not give effect to that right, and B. may develop rules of the common law to limit the right, provided that the limitation is in accordance with Section 36, subsection 1. It seems to be generally agreed among the commentators that these provisions permit some degree of direct horizontal application, but the extent of that application is uncertain for two reasons. First, Section 8, subsection 2 makes it clear that not all fundamental rights bind persons in the private sphere, and a particular right will apply only to them if and to the extent that it is applicable. Most socio-economic rights, such as the rights to housing and healthcare, are probably intended to apply only against the state. Secondly, it would seem to be clear from the wording of Section 8, subsection 3, that when a particular right in the Bill of Rights does not find application in the private sphere, it does so through the common law, rather than directly. The court, in giving effect to the right, must apply and, if necessary, develop the common law. As Cockrell points out, Section 8, subsection 3 serves to implement a compromise between direct and indirect application of the Bill of Rights, since even if a constitutional right has been found to apply directly against a private person in terms of Section 8, subsection 2, it is the common law which must be applied or developed in order to give effect to that conclusion. This directive amounts to a clawback from a position of full-scale direct horizontality. for it instructs that the direct application of constitutional rights against private agencies must be mediated by the intervention of the common law. In Barkhuizen versus Napier, a majority in the Constitutional Court expressed grave doubts about the appropriateness of testing the constitutionality of a contractual term directly against a provision in the Bill of Rights. Any attempt to do so, said Nkobo, would encounter serious difficulties. If the contractual term limited a right in the Bill of Rights, such as the Section 34 right of access to courts in that case, the court would have to inquire whether the limitation could be justified under Section 36 of the Constitution. However, Section 36 stipulates that a right in the Bill of Rights may be limited only in terms of a law of general application, and a term in a contract is self-evidently not such a law. Although presenting difficulties insofar as direct application of the Constitution is concerned, Section 172, subsection 1a of the Constitution requires a court to declare invalid any law or conduct that is inconsistent with the Constitution. But a contractual term is neither law nor conduct. In light of these difficulties, the majority preferred an indirect application of the Constitution to the contractual dispute before them, apparently under Section 39, subsection 2. The proper approach to constitutional challenges to contractual terms, said Nkobo, is to determine whether the term challenged is contrary to public policy, and what constitutes public policy must today be discerned with reference to the fundamental values embodied in the Constitution, and in particularly in the Bill of Rights. Only Langa expressed any doubts in this regard. While he agreed that indirect application under Section 39, subsection 2 might ordinarily be the best way of addressing the problem, he was not convinced that Section 8 does not allow for the possibility that certain rights may apply directly to contractual terms or the common law that underlies them. Ultimately, it made little difference which approach one adopted, because in his view, the distinction between direct and indirect application would seldom be outcome determinative. As is evident from the discussion above, the first and most obvious way that the Constitution may have an impact on a contract, whether directly or indirectly, is by rendering unenforceable the contract itself, or some of its provisions. Another way in which the Constitution may affect a contract is by rendering invalid the exercise of contractual power by a contracting party. For example, the power to terminate a contract by giving the other party the requisite notice, or the power to withhold one's consent to a subletting or to the cession of rights derived from the contract. Traditionally, the courts have been reluctant to second-guess the exercise of contractual powers by questioning the substantive manner in which the power has been exercised. For example, if a contract gives a party power to terminate a contract in certain circumstances, and that power has been exercised, the courts have, in the past, not concerned themselves too deeply with the party's reason for exercising the power, nor have they asked whether the party acted in bad faith, or unreasonably, or immorally, or for some improper purpose in exercising the power. Under the influence of the Constitution, that reluctance now seems to be dissipating, at least to some extent. Way back in 1997, Crockwell predicted that the courts would, in future, be prepared to intervene if a party to a contract exercised a contractual power in a manner that failed to respect the constitutional rights of the other party, in particular the right not to be discriminated against unfairly, for example, where a landlord terminates an indefinite lease by giving the required period of notice, motivated by the discovery that the tenant is homosexual, or if he or she withholds permission for the premises to be sublet because he or she objects to the race or religion of the prospective subtenant. That prediction has now been fulfilled. In Bredenkamp versus Standard Bank of South Africa Limited, the Supreme Court of Appeal stated that a prima facie innocent term in a contract would not be enforced if its enforcement would unjustifiably affect an identified constitutional value, and gave the example of a landlord refusing consent to a subletting in circumstances amounting to unfair discrimination. Even where no constitutional value was implicated, the court suggested the exercise of a right to terminate a contract for any reason might be qualified by considerations of good faith. If the right were exercised for bad reasons, this might amount to an abuse of rights. And in Botha versus Rich, as noted earlier, the Constitutional Court went so far as to disallow an act of cancellation for material breach, on the grounds that the consequences of such cancellation would be an unfair and disproportionate penalty for the breach. Already it will be seen the Constitution is exerting a strong impact upon the law of contract. How far the courts will be prepared to go in reshaping established principles and doctrines of contract law to conform to the perceived demands of the Constitution remains to be seen. Will the principle of freedom of contract be undermined to the extent that a party is compelled to contract with another on constitutional grounds? Consider the following. A refuses B's cash offer to buy her house because she objects to B's race or religion, and then sells the house on identical terms to C. Clearly, A's conduct amounts to unfair discrimination in violation of B's right to equality guaranteed by Section 9 of the Constitution. For this wrong, B would surely be entitled to damages, if necessary by extending the ambit of the common law actio injuriam, but would a court be prepared to set aside A's contract with C and compel A to sell the house to B? One might think not. However, the decision of the Constitutional Court in Hofmann versus South African Airways suggests otherwise. H's application for employment as a cabin attendant was turned down by SAA on the grounds of his HIV-positive status. The court held that this amounted to unfair discrimination and ordered SAA to make him an offer of employment. And then you can just study that small diagram. Okay, and then the counterpoint. The decolonization of South African contract law. Some argue that post-apartheid South African law uses liberal human rights theory to mask continuing hegemonies in society. Critical theorists have drawn attention to the fact that inequality, poverty, and social class have some strong racial element in South Africa. Radical black politics has become prominent as a result, including calls for the decolonization of law and legal education. South Africa's previously revered blend of civil and common law, the product of centuries of development by white jurists, faces new questions as to the role of African law, politics, and philosophy in the transformation of law and legal culture, including in contract. Chainock argues convincingly that the formative early 20th century the laws for black and white South Africans were segregated, resulting in official customary law and the common law. Issues surrounding the status of black contracting parties, as well as the need to protect white political and business interests, led to the dominance of the common law over customary law in commercial transactions. The result today is that customary contract law, as represented in South Africa's textbooks and law reports, consists of specific family and community-orientated transactions. What is the solution if we are to decolonize contract law? This is open to debate. One possibility, seemingly preferred by the Constitutional Court, is to incorporate African values such as Ubuntu into newly synthesized common law. A more radical solution could be a new contracts code produced by a democratically elected legislature and incorporating African law and values into a unified, decolonized law of contract. Such a text would be unlikely, however, to stray far from the dominant world models. Given the universal nature of commercial contract transactions and the role of international trade. Indeed, the core problem of inequality is unlikely to be eradicated through a change in the governing contract regime. The solution to this must lie in other fora.